So for today's case, we've got Mississippi versus Tennessee. And as you can see here in the header, this is number 143 original, because this is a case between two states, which means that pursuant to the Constitution, the Supreme Court is the trial court. So this case starts and ends in the U.S. Supreme Court. So this is a case of original jurisdiction versus appellate jurisdiction. The Supreme Court is the trial court. Fun. All right, so let's read this case and see what Mississippi and Tennessee are fighting over. Mississippi brings this original action in which the Supreme Court is the trial court against Tennessee for damages and other relief relating to pumping of groundwater by the city of Memphis for the Middle Claiborne Aquifer, a valuable water resource that lies beneath 8 states. Yeah, unsurprisingly, this deals with water rights. That is very often what the disputes between the states wind up to be. It winds up to be a water rights thing. Mississippi argues that Tennessee's pumping, using wells Mississippi concedes are located entirely inside of Tennessee, siphons waters away from Mississippi and amounts to a tortious taking of groundwater that's owned by Mississippi. Hey, we own that aquifer too. Mississippi expressly disclaims any equitable apportionment remedy, arguing that the fundamental premise of this court's equitable apportionment jurisprudence, that each opposing state has equal right of use of water at this issue, does not apply to the dispute. So one of the things might be, okay, it's an equity issue because they all own the same water, but they all own the same water. So one of the ways you can deal with this is you deal with this in property law a couple different ways. Right, so you can deal with this as basically tenants in common would be one way, and they basically owe duties to each other, and so they might be responsible for apportioning out the gains that occur from the property to each other. They all have an equal and undivided right to the property. This is called a tenant in common. And then if you have a right of survivorship, it's called a joint tenancy. This is going too much into property law. But these are concepts known to property law, right? Everyone owns the property together, either with right of survivorship or not. And everyone might owe a duty to everyone else in terms of their account of the use of the property. So this is one of the ideas. Maybe that's the issue. But Mississippi is saying this is not the issue. Okay. The special master appointed by the court to assess Mississippi's claim determined an aquifer is an interstate water resource and that equitable apportionment is an exclusive judicial remedy. All right. So we have this term special master. Ooh, very fancy term, right? And it actually falls into the category of being a big deal. The Supreme Court uses them pretty much every time in original jurisdiction cases because they are the trial court. So technically they could just have the trial themselves, but they're not going to. So they're going to appoint a special master basically to do it for them. But then they get the chance to review everything for the first time. So it's all de novo, no matter what it is, because they are the trial court. So they get to review the special master's review, factual findings or otherwise, all de novo. You sometimes see this, although much more rarely, at courts of appeal and even occasionally at trial courts in particularly complicated factual situations, particularly where they're technically complicated. And the court feels like they don't have the right requisite factual background. So you will see sometimes courts appoint a special master. Basically, it becomes a mini judge. And they're the one that basically hears all the case. And the judge sits on top of the whole thing of review and can basically still do whatever they want. So they can ignore the special master, they can do whatever they want. But it's a way to basically appoint a neutral arbiter within the court system. And so you'll sometimes see this. And so being appointed as special master is a big deal. Being appointed as special master at the U.S. Supreme Court is a very big deal, particularly in these water rights cases, because sometimes they go on forever. And sometimes you're a special master for 40 years or something, because sometimes these water rights go on forever. So that's basically what happened. The Supreme Court basically appointed sort of a kind of mini judge that the Supreme Court can absolutely do anything with regards to because they're just assisting, but it's a big deal. And the Supreme Court usually listens because that's the point. Because Mississippi's complaint did not seek equitable apportionment, the special master recommended the court dismiss the complaint, but grant leave to amend. Mississippi challenges the recommendation to dismiss. Tennessee objects to the recommendation to grant leave to amend. So they are not, both of them are unhappy. Tennessee wants this to be dismissed without any redress, and Mississippi wants to not have the equitable remedy. The court's going to split the baby. Here, the waters of the Middle Claibor Aquifer are subject to judicial remedy of equitable apportionment. Mississippi's complaint is dismissed without leave to amend. That's a harsh remedy. Okay, let's read some more. The doctrine of equitable apportionment arises aims to produce a fair allocation of shared water resources between two or more states, based on the principle that states have equal right to reasonable use of shared water. This court has applied the doctrine to interstate rivers and streams, to dispute over interstate river basins, and in situations where pumping of groundwater has affected the flow of interstate surface water. The court has also applied the doctrine to fish that migrate between the Pacific Ocean and spawning grounds in the Columbia Snake River system, traveling through several states during their lifetime. Who gets control of the fish? These are the kind of things that the Supreme Court has to solve. The court has not before addressed whether equitable apportionment applies to interstate aquifers. So this isn't a river or a water basin. This is underground. So we've never before decided that issue, which I suppose we could decide differently if we want to. Equitable apportionment of the aquifer is sufficiently similar to past applications of the water for several reasons. I mean, I would think so. How is underwater water different than overland water? How is under the land water different than over the land water? It's not really that different, or at least not different enough. First, the court has applied equitable apportionment when transboundary water resources are at issue. Here, the Middle Claibouron Aquifer's multi-state character seems beyond dispute. Second, the Middle Claibouron Aquifer contains water that flows naturally between the states, and the court's equitable apportionment cases all have concerned this kind of water, or the fish that live in it. We are about controlling the water, and we're about controlling the fish. Fine. While Mississippi contends the natural transboundary flow of the aquifer is slower than some streams and rivers, sure, the court has applied equitable apportionment even to streams that run dry from time to time. So even though that there is no water, we are still going to apportion the non-existent water, because that's the level of petty that we have to deal with at the U.S. Supreme Court level as the states fight each other. The speed of flow does not place the aquifer beyond apportionment. Finally, actions taken in Tennessee to pump water from the aquifer clearly have effects on the portion of the aquifer that underlies Mississippi. Tennessee's pumping has contributed to a cone of depression that extends miles into northern Mississippi, and Mississippi itself contends this cone of depression has reduced groundwater storage and pressure in northern Mississippi. So pumping the water out has caused the land to sink. Such interstate effects are hallmarks of the court's equitable apportionment cases. For these reasons, the court holds the judicial remedy of equitable apportionment applies to waters. Yeah, basically, if multiple different states control the same water, they all have to play nicely with each other. And you all get it equitably. You all have to play nice. No one gets water superior to anyone else's. So just because you're further up in the river doesn't mean you get to steal all the water and or all the fish. And just because you've drilled a well into the aquifer that is within the boundaries of 8 different states doesn't mean that you get to control all the aquifer water. You have to play nice with the other children. You all get rights to the water collectively, and you have to play nice. And if not, then the Supreme Court has to come in and deal with how we have to deal with the fish. Left unresolved is whether or not those fish are bees, and if so, how that impacts the analysis, but maybe it's a different decision for another time. The court rejects Mississippi's contention that it has a sovereign ownership right of all the water beneath its service that precludes application of equitable apportionment. I mean, if that were true, that would apply to every state. And then it's just who can pump the water the fastest, which obviously is a somewhat disfavored outcome. The court has consistently denied proposition that a state may exercise exclusive ownership or control of interstate water flowing within their boundaries. It's interstate, so no. Although the court's past equitable apportionment cases have generally concerned rivers and streams, no basis exists for a different result in the context of the Middle Claibouron Aquifer. To the contrary, Mississippi's ownership approach would allow upstream state to completely cut off flow from a downstream one, a result contrary to the court's equitable apportionment jurisprudence. Yeah, it's not just like whoever the water flows through first. All the states get to have some water. Water, not a drop to drink. Everyone has to play nice. The court's decision in Tarrant Regional Water District does not support Mississippi's position. Tarrant concerned whether one state could cross another's boundaries to access shared water resource under the terms of an interstate compact. An interstate compact would be where there's an agreement, so, okay. The court did not consider equitable apportionment because the affected states had negotiated a compact to their respective rights. So yes, in this particular situation in Tarrant Regional, apparently the states reached an agreement between themselves on the whole thing. So then that became the law. They have an agreement They have a contract. And so, if they have an agreement, great. That's law. If we don't have an agreement, then we're into equity, which is kind of not law, but sort of is. It's a different theory of things. And yeah, so if there's law because you have contract, then great. And so we didn't have to consider the equity because we had law. Fine. To the extent that Terra stands for a broader proposition that one state may not physically enter another to take water in the absence of an agreement, which, that principle is not implicated here. Surprising literally no one state cannot cross into another state's boundaries to take their stuff. That's when one state crosses another state to take their stuff, wars have been fought over less. So, no. The parties have stipulated that all of Tennessee's wells are drilled straight down and do not cross the border. While the origin of the interstate water resource may be relevant to the terms of the equitable apportionment, that feature alone cannot place the resource outside the doctrine. Because the waters contained in the aquifer are subject to the equitable apportionment, because the aquifer exists cross-border, the court overrules Mississippi exceptions and adopts a special master recommendation to dismiss the bill of complaint. So, no. Mississippi has neither sought leave to amend its complaint nor tendered a proposed complaint seeking the equitable apportionment. The court does not address whether Mississippi should be granted such leave and sustains the recommendation to sustains the objection to the special master's recommendation to grant Mississippi's leave to amend. Wow. So, we don't address whether or not you should be granted leave, but we sustain your objection to the special master who said no. So maybe you lose all the things because the special master said no. So maybe you lose your rights because you were a greedy Mississippi, and now you don't get any water. So sucks to be you. Thus, that brings us to the end of the case of Mississippi versus Tennessee, a case of original jurisdiction in the U.S. Supreme Court. Yes, one state can sue another, and when that happens, the Constitution is absolutely clear. The only court that can decide issues between states is the Supreme Court. The Supreme Court is the trial court, and also the Court of Appeals, and also the Court of Last Review. It's a nice place to be, I guess, if you're the Supreme Court. It's like we start and finish here. So yeah, Mississippi and Tennessee are suing each other over water, which is typically how these things go. And they say, yeah, you have to share the water. And then they say, in a nice little burn to Mississippi, because you didn't want to play nice, we're not going to let you amend your complaint. So Tennessee gets to steal your water and there's nothing you can do about it. Man, that's a lot of burn. Or at least that's the recommendation from the special master. Maybe if Mississippi goes back with hat in hand and asks really, really nice, the special master will reconsider, which they can, mind you, because the Supreme Court is the trial court, remember? And the trial court can always reverse itself on these issues, and the special master is acting as the trial court. So the special master might be able to change their mind, and that would be fine because it's just the Supreme Court basically changing their mind. But they might have to learn to play nice with others. And at least for the moment, that brings us to the end of discussion of this case.